Welcome to Meet the Court. I'm your host, Ellen Procida. Meet the Court is a public service brought to you by the Superior Court of Atlantic and Cape May Counties and the Cape May County Technical High School. This program is designed to better inform you, our public, of the inner workings of the court and the role of the judiciary in our communities. Today our topic is child support and recent changes made to the child support law in New Jersey. Our speaker today is Dawn Doherty, team leader from the Cape May County Child Support Unit. Welcome, Dawn.
Thank you.
How are you?
Good.
So before we start talking about those changes to the law, can you tell us a little bit about yourself?
Sure. My name's Dawn Doherty. I am a court services supervisor over in the child support unit at the courthouse. I have been involved in the child support program for 16 years. I am very passionate about collecting child support. My husband and I are raising a family here in the county, so we truly do understand the needs of the community.
So thank you. So let's start with those changes. What are the changes to the law and how are they going to impact the community?
Well, the new termination law now establishes a set age for termination of child support. The child support can terminate upon a couple events. If a child gets married, if a child dies, or if the child enters active military service. That will automatically terminate a child support order at this point with the new law. But it also establishes an age of 19 when child support obligations should terminate.
Okay. So just to ask, since we were indicating this is a change, what was the age prior to this change?
Actually, the state of New Jersey didn't have an age of termination or emancipation. We were the last state to not have an age, so it was definitely overdue, and they had been working on the bill for a very long time. Before, you would have to file a motion in order to terminate child support, or it could have terminated naturally through a court order. It was already in the court order. But there was no set event. As long as the child was a full-time student, the child support continued, and we have children on orders that are quite not children anymore. We have 30 and 40-year-olds on child support orders. So this law is going to solve a lot of problems that those cases would bring.
So you talked about having orders where individuals are receiving child support later on in life. When does this law go into effect?
It went into effect on February 1st of this year.
Okay. And it's automatic as soon as it went into
It began February 1st. There were a lot of requirements on noticing, so child support orders have not terminated at this point, but the noticing and the all of the awareness campaigns are out there, and in 180 days we'll have our first termination starting.
Okay. So this leads me to my next question, actually. You talked about noticing. For members of our audience that are receiving child support, moving forward, will they receive notification that the order is terminating?
Well, it was quite a project to figure out how to implement it, because obviously there was going to be a lot of backlog. There were going to be a lot of cases that had to get noticed right away, and nobody wanted anybody's child support to terminate day one. So what they did is they're sending out any child that was over the age of 19. Everybody got their notices on February 1st. Those notices give a 6-month warning as to when the child support will actually terminate. So the first time child support will terminate for any of these cases under the new law will be August 1st.
Okay.
So, and there'll be several noticing, there'll be several letters sent out, and there'll be several opportunities to ask for continuance of child support.
Okay. So again, kind of opens up another question for me. What if the person receiving the child support, they believe they have extenuating circumstances that takes them, are there exceptions to that 19 rule?
There are absolutely exceptions to the rule. Child support terminates upon the age of 19 unless the child is a full-time student and a request for continuation is made. The child could also be disabled. At that point, a request for continuation could be made. But the law does state that no matter what, either disability or full-time student status, child support will not continue over the age of 23 through the child support system.
And there are no exemptions to that?
There are absolutely no exemptions to that.
Okay, so you indicated about people will receive notifications. What is the process if they are looking to extend that child support beyond the age of 19?
All right, let's start with it's February 1st. All of the notices go out. They are letting both parties know, the custodial parent and the non-custodial parent will get noticed that their child is over the age of 19 and that child support will be terminating in 180 days unless. And the unless is full-time school status is provided, proof of full-time enrollment is provided, or proof of disability is provided. Now, the proof of disability has to be very specific. A child has to be labeled disabled by a state or a federal agency, which basically is Social Security income, SSI, or be deemed incapacitated by a court order. So they're the only circumstances to file if the child, or provide proof if the child is disabled. As far as full-time school status, we absolutely need to receive from the custodial parent a certificate of enrollment, and schools will give you a certificate of enrollment. It has to say that the child is full-time, and then a termination date has to be given by the custodial parent, and that termination date is the expected date of graduation. Cannot exceed the 23rd birthday of the child.
Okay, but you did get me to my question. I thought, are those extenuating? So with that, and you talked about children that would be disabled or may be disabled, are there other benefits that go along with child support, like medical coverage or dental coverage, and what happens with those benefits?
The medical support goes hand in hand with the child support obligation. Medical support is supposed to be addressed in every situation, in every case, and mostly it is. So medical support would go hand in hand, meaning that it would also continue or terminate. Now, that kind of conflicts a little bit with the state of New Jersey and what they allow for medical. Children are allowed up to age 26 to be covered under their parents' health insurance in some situations. The letters that we send out when we are terminating child support do say that the employer is no longer court ordered to cover the children, but, and it's very strongly worded, that they are to have a conversation with their employee before taking a child off of medical, because it is still an optional. It could be in the employer, in the business, an optional program for the child to remain enrolled in medical coverage.
So it sounds just the importance of sharing information here.
Yes.
We're going to take a short break, and when we wrap up, or when we come back, we will follow up on this conversation regarding the changes. Thank you.
Thank you.
This is Ellen Procida from Meet the Court. We'll be back after this short break.
Did you know that the Superior Court in Atlantic and Cape May counties will provide interpreters for you to assist you with your day in court? You can request an interpreter when you file your case or when you call Interpreter Services at 609-594-3496. We have Spanish interpreters on staff, and we also support all the languages by providing you with a court-certified interpreter for your court proceedings. ¿Sabía usted que la Corte Superior de los Condados de Atlantic y Cape May proveerá intérpretes para usted para ayudarle con su día en la corte? Usted puede solicitar un intérprete cuando presente su caso o puede llamar al servicio de intérpretes al 609-594-3496 para solicitar uno. Tenemos intérpretes de español en nuestro personal y también apoyamos a otros idiomas que le proporciona un intérprete certificado por el tribunal para su proceso judicial.
Welcome back to Meet the Court. I'm your host, Ellen Procida. Today we are talking about changes in the New Jersey child support law, and we're joined by Dawn Doherty, team leader from the Cape May County Child Support Unit. Welcome back, Dawn.
Thank you.
When we left for break, we were talking about the absolute requirement that the child support terminated at the age of 23, and we were discussing disabled children. Mm-hmm. And I imagine for our audience there may be concerns that what do they do in the event they have a disabled children to continue to assist and support that person after 23?
All right. The age of 23, I can't tell you why that was picked, but I can tell you that what it means is that we are no longer able to collect the support through the child support system, through the computer system, New Jersey Kids. And that is because we are a federally funded program designed for children. So the federal funding is not going to allow us anymore to cover what would be deemed as an adult. Now, disabled children are obviously a fragile part of our society, and we don't want there to be absolutely no further support for them. There is something called financial maintenance that a person can file for, and a child can be deemed disabled by a state or a federal agency, or they can be deemed incapacitated by a court order. So in either situation, that child is a disabled child. the custodial parent or non-custodial parent has the right to come back to court and ask for a continuance. It just would not be through the system. And there's a number of arrangements that can be made. It could be a private, just between the parties type of arrangement if that's the relationship. There can be further orders through the civil division as far as wage garnishments and getting support forcefully. But what we are encouraging people that are in that situation is to go to our family divisions and to begin asking these questions and filing motions and seeing what their rights are.
But certainly it doesn't sound like the court order would preclude the parties, the parents, from speaking to each other and continuing an arrangement that works for their child.
Unless there is a domestic violence restraining order,
Right.
no, there's nothing precluding the parties from continuing to support their child outside of the courts on their own in any capacity.
Okay. What if someone has multiple children and one of the children is reaching that age, whether that age be 19 or the absolute age of 23, but they still have children within the age to get child support? What happens with those orders?
Okay, this is going to be a confusing part right out of the gate because we haven't been doing this. So suddenly we start sending these letters out. And each letter is for each child. So if you have 5 children, let's say 3 are over the age of 19 and 2 are not, you're getting 3 separate letters. And all of them are indicating, this child's being terminated from child support, this child's being terminated, but obviously there's still children under the age of 18. What will happen is if the 3 children are indeed taken off the order, that order is not going to change financially if it is an unallocated order. And what that means is most child support orders, in fact, I think about 98% of the Cape May child support orders are unallocated, meaning that they're not per child. So if you had 2 children on the order and that the order was for $100, one might think that it's $50 for child A and $50 for child B. That would make sense. But that would be an allocated order. Like I said, 98% of our orders are unallocated, meaning it's family support. It's for both children, and removing one does not change that amount. It doesn't mean it can't change the amount. It just means that it doesn't automatically change the amount. So if we terminate one of those 2 children, the child support is going to continue to charge at $100 a week and not go down to $50 a week unless there's a filing. If there is a filing by either party to look at the child support guidelines and run the numbers and put both parents' income into the system again and come out with a number for one child as opposed to 2, then that would change. But just this process, just this administrative process is not going to change child support as long as there is an active child and it is an unallocated order.
Okay. And I think that would calm any concerns that, custodial parents may have regarding that. Thank you. You talked about the extension of child support or continuing when an individual is a full-time student. So let's just talk about a few of those.
Okay.
One, what is defined as a full-time student?
Well, that's always controversial. We used to say it was 12 credits. It was just like a known thing, 12 credits equals full-time. Well, that's not the case anymore, especially with all the different type of learning we have. We have internet learning, we have, off-site learning, in-school learning, all kinds of stuff going on. So we are now defining full-time status as whatever the school is defining as full-time status. So when the custodial parents are trying to obtain these letters, they have to be sure that somewhere on that letter it says full-time. We've been getting stuff in the mail that is wonderful, transcripts, official, nice raised seals. They're very pretty, but they don't say the full-time enrollment status of the child, and they are being denied. One thing that is also interesting is that parents cannot obtain these letters because the children are adults now. So it is quite a process, and you have to work with your child, and you have to make sure that these letters are coming to you. There is also a warehouse, a clearing warehouse that will certify full-time enrollment for the lending companies that parents can apparently utilize. There's a small fee. I believe it's just a few dollars. We can accept letters from that too, but every school has to subscribe to that service, and some schools don't. So I would begin by talking to your child and having them find out if they can obtain an enrollment certification. They have 6 months, or they have a little less than 6 months, about 4.5 months to get from the time they're noticed to get these letters. So we're hoping that provides them with plenty of time. And if they do provide information that isn't adequate, we reach out by phone. There's signature at the bottom of these certifications, and we really stress how important it is to keep your phone number updated, so that if indeed something is submitted in error, that we can reach out to you right away and tell you what you need to provide to us so that a child isn't terminated, in error. And also, so important in this, and what we're finding out is very important to keep your address updated. If we have a bad address, that does not stop this process. So service is not an issue. If the letters go out and they come back, and we know we try to reach out through emails and phone numbers and we're not successful, the child support is going to terminate, unfortunately.
So again, the importance of communication between the parties and your unit. Right,
Absolutely.
to ensure everyone's on the same page.
Absolutely.
Thank you very much. We're going to take a short break. And we come back, just talk about, again, some of the other nuances to the law so that our audience fully understands. Thank you. This is Ellen Procida for Meet the Court. We're going to take a short break. We'll be back with you shortly.
Did you know the Superior Court in Atlantic and Cape May counties has a website that has a lot of very helpful information? You can access the site at njcourts.com. Click on the tab across the top that says Courts, then click County Local, then click Atlantic Cape May. This brings you to the home page. From there, you can click on any of the links to find the information you're seeking.
Welcome back to Meet the Court. I'm your host, Ellen Procida. Our topic today are the changes to the child support law in New Jersey. And our guest is Dawn Doherty, the team leader from the Cape May County Child Support Unit. Welcome back, Dawn.
Thanks, Ellen.
So through this conversation, I think we discovered that there are probably a lot of what ifs for our audience members, some questions. So let's talk about those nuances. We were talking about children in school. What if a child is full-time, the necessary documentation is submitted, and then the child leaves school? What happens to the child support then?
Anything that happens after our office makes the determination, it's finalized. If any changes occur, the next day, the next week, the next month, the next year, a motion has to be filed by one of the parties if they want the termination date to now possibly move forward. We cannot change anything administratively. Either party is welcome to come in and file for a change in that case.
Okay. So the child in this situation leaves school and then soon after, within that 23 age time frame, decides to return to school. Does the child support just automatically start back? How does that work?
No. What would happen is if, we terminate and the child support and the child decides to resume full-time status before the age of 23, the custodial parent is welcome to come back in and file a motion and ask for further support from the non-custodial parent.
Okay, so essentially it really comes down to the parties have to take responsibility.
Yes.
If they want to reinitiate.
Yes, after that final decision is made and the court orders are sent out, there's nothing by law that my office can do to change that.
Okay. With the law being new, what if someone has a judgment of divorce or a court order that indicates a date or an age, I should say, different than 19 or 23?
It can actually indicate dates. They do that. And they also indicate events, such as upon graduation from a post-secondary school. In that situation, there is, when the first letters go out, there is a request, if there is a court order existing, to send it in. And the custodial parent or the non-custodial parent can send that documentation in. And my office would review the documentation, and if indeed there is an event already in the court order before the age of 23, so even if the court order says 25, we have to make it the 23rd birthday. But that would be reviewed, and then the new court order would be automatically issued based on the judgment of divorce or whatever it said in that court order.
And this form, that request for continuation of support, that was sent to them with these the initial notifications?
It is sent to the custodial. It's sent to both.
Okay.
The custodial parent, and the non-custodial parent gets a chance to submit a court order. But the custodial parent gets a chance to submit the documentation on education and disability. He or she is the only one that can present that information.
And what if, the possibility people lose things? So as a recipient, what if I lose my form? Where can I get another one?
Or you didn't ever get it because your address wasn't correct. The best thing is to log on to the website, which is njchildsupport.org, and you can log on and you can access your account if you have your PINs. If not, and you can reprint it right from the website, it's wonderful. If not, you can call the 877 number, which is 877-NJ-KIDS-1 or 877-655-4371. And you can obtain your PIN and log on, or you can request the documentation be sent out to you right from the 877 number. Or you can always come into the office and we can always reprint it and give you all the documentation you need.
Sounds like you're offering individuals as much resource and information as you can to help them, navigate the process.
We are trying. Our goal is not to terminate child support. Our goal is to collect and enforce child support.
Okay. You spoke, so when we talked about the effective date, which is February 1st, and there's this window, right, that you're getting the information out, and there's somewhat of a delay. What are some of the things you just want to emphasize so our audience knows about this window, their flexibility if they
Right.
have it?
Right. Well, the courts are giving 6 months to allow people to file if there's something that they need to come in and actually file for the courts. After 3 months goes by, we're sending out another notice that's more strongly worded that this is terminating. If you do nothing, it's going to terminate. 6 weeks later, my office is unable to do anything. The system gets locked down. So 45 days out from the proposed termination date. In this situation, it's going to be about mid-June. After that, if you run into the office with the certification of enrollment, it's not going to make a difference. The system's going to shut me down. I'm not going to be able to continue any support, and you're going to have to go and file a motion, and there are fees associated with motions. So we emphasize that when you get these letters, act upon them. You do have that window of opportunity, but once we're 45 days out, we're not going to have a chance.
So they can do this without actually going through that formal process as long as it's within that time frame.
Absolutely.
Excellent. So I want to ensure that our audience is clear because we talked a lot about that age of 23. There are no exceptions to that age?
There are no exceptions if the child support began in New Jersey, and New Jersey controls the order. It's called controlling exclusive jurisdiction. If we have that, it's not a problem. This law will absolutely affect your order, and it will go into effect. It did go into effect February 1st for all children over the age of 19. If your order started in another state, and New Jersey is involved somehow, enforcement, monitoring, but it's through the New Jersey system, but another state has that controlling exclusive jurisdiction, then we have to go with whatever the other state's laws are. Most are before the age of 23. They're usually more strict, not less strict, but in that situation, you will not be receiving these letters. You will be receiving whatever documentation the other state provides.
So where should they expect to get the documentation from? So will they receive both the termination from here and from the other state
No,
or the other state?
They would only be receiving it from the other state. Conversely, if you live in another state and you have a New Jersey order, we will be sending out the documentation to your other state's agencies. So if you're watching this and you now live in Florida, but New Jersey still controls your order, we will be sending that documentation to the child support agency in Florida should the case be registered in both states. So that's another thing you kind of have to keep your eye on because you don't want to leave it up to a state agency to get that information to you. I would probably be proactive and log on and try to get that information myself.
So if the individuals want to be proactive, and part of that being coming into your office as you've offered, right, as assistance, where is your office located?
We are at 9 North Main Street in Cape May Courthouse. In the Superior Courthouse building. My specific office is on the basement level in the back of the courthouse.
Thank you, Dawn. I think as a result of this show, they'll certainly be clear about those changes, but if they have additional questions, they know where to go.
Absolutely.
We're just about wrapping up today. Thank you for joining us, our audience. This is Ellen Procida, your host for Meet the Court. We'll be back with you for the next program.